Final case on the docket for Friday, February 4th, 2022 is appeal number 124083 in the matter of Jacqueline J. Spradling, original action and attorney discipline. Briefs both sides. Your Honor, this concludes the docket for the week of January 31st through February 4th, 2022.
Counsel, would you please come to the lectern and enter your appearance?
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office.
Morning, Chief Justice Lukert and Justice of the Kansas Supreme Court. L.J. Leatherman on behalf of the respondent, Jackie Spradling.
Mr. Vogelsberg?
May it please the court, Madam Chief Justice, I'd like to reserve 3 minutes for rebuttal.
3 minutes is reserved.
This is an original proceeding in attorney discipline involving respondent Jacqueline J. Spradling. The respondent was admitted to the Kansas bar in 1992. This matter involves 2 separate complaints, DA 12-581 and DA 13-174. DA 12-581 concerns respondent's prosecution of Dana Chandler in Shawnee County District Court for 2 counts of premeditated murder. Due to several statements that respondent made during her opening and closing arguments at the Chandler trial, this court reversed Chandler's convictions and remanded for further proceedings. The second complaint, DA 13-174, concerns respondent's prosecution of Jacob Ewing in Jackson County District Court for several sex crimes and related charges. The Court of Appeals ultimately reversed Ewing's convictions for cumulative error due in part to several statements that respondent made during her closing argument. Both disciplinary complaints proceeded to a hearing before a panel of the Kansas Board for the Discipline of Attorneys starting on December 7th, 2020. At the conclusion of a 5-day hearing, the Disciplinary Administrator's Office argued that there was evidence of numerous rule violations and recommended that the respondent be indefinitely suspended from the practice of law. Subsequently, the hearing panel issued its report on June 3, 2021, concluding that respondent had violated the following rules: 1.1 competence, 3.1 meritorious claims and contentions, 3.3A1 knowingly making a false statement of fact to a tribunal, 3.4C knowingly disobeying an obligation under the rules of the tribunal, 3.4E alluding to a matter in trial that was not supported by admissible evidence, 8.1A, knowingly making a false statement of material fact in connection with a disciplinary matter, 8.4C, engaging in conduct involving dishonesty, and 8.4D, engaging in conduct prejudicial to the administration of justice. The hearing panel recommended that respondent be disbarred. On July 14, 2021, the respondent timely filed exceptions to the hearing panel report, challenging the panel's findings of fact, conclusions of law, and recommended discipline. In her subsequently filed brief, the respondent raised 2 issues. The first issue was whether this court's definition of prosecutorial misconduct in State v. Sherman should be applied to disciplinary cases involving prosecutors. In other words, the respondent contends that when a disciplinary case involves a prosecutor, in order for that prosecutor to be found in violation of any Kansas rule of professional conduct, the ODA is required to prove by clear and convincing evidence not only elements of the particular KRPC that's at issue, but also that the prosecutor acted with a level of culpability that exceeds mere negligence. Specifically, that the prosecutor acted with knowledge and intent outside the wide latitude afforded to prosecutors or with a malicious or gross disregard for the fair trial rights of the defendant. Respondent's argument is without merit for several reasons. First, Sherman is an appeal of a criminal case. There is no language in Sherman to indicate that this court's definition of prosecutorial misconduct in the context of a criminal appeal should be treated as an element that must be proved in an attorney discipline case.
Let me stop you there and just ask, does this legal debate matter, at least with respect to the majority of the findings? Because as I read the panel report, they actually made culpable mental state findings.
Made intentional findings with several rule violations.
For most, not all, but
Not
at
all.
least a lot of them.
But yeah,
So does what you're discussing now matter with respect to those?
for those rule violations where the panel found intentional conduct, no. But I'm also raising this argument for future cases where a prosecutor may have to answer to a disciplinary complaint and confirming that Sherman's standard does not apply to that case.
While you're interrupted, let me, kind of a substantive question, also procedural. And it's referenced on your office's brief on page 23, where you note that the respondent took exceptions, they basically all of the factual findings and legal conclusions and all of that. I don't understand some of those exceptions because they relate to paragraphs that are just recitations from transcripts and things like that. So, you know, there's a little bit of overkill there. But you make the argument in your brief that that raises potentially some preservation or waiver issues, and I want to develop that a little bit. And I just want to ask you more about that because it's hard to make. I mean, you get through this, and they take exceptions. The respondent takes exceptions to just the sky is blue today. Today,
Right.
in some of these paragraphs, especially the factual findings. So, what are we to make of that, if anything?
Obviously, they filed their exceptions, so under Rule 228C to initially preserve it. But then this court has cited or stated in numerous cases in Murphy, in Ray Murphy, 312 Can 203, in Ray Hodge, 307 Can 170, that if you don't subsequently brief those issues, then you waived it. So in this case, they took exceptions to the panel's findings of fact, but in the initial brief, there was no issue challenging whether or not the panel's findings were supported by clear and convincing evidence. And so our argument, noting that on page 23 of our appellate brief, is noting that that issue has been waived. And so essentially the only two issues that are before this court now are whether State v. Sherman's standard or definition of prosecutorial misconduct should be applied in a disciplinary case involving a prosecutor. And then the second one is whether or not the panel erred in not admitting the polygraph exam results. Those were the only two issues that were briefed in their initial brief.
One thing that the respondent does in her brief, though, is sort of lay out all the other facts that are the evidence that they tried to present that the panel didn't talk about. So what do we do with that?
Essentially, that argument would be asking this court to reweigh the evidence, something that it cannot do when it's reviewing whether or not clear and convincing evidence supports the panel's findings. So, in our brief, we laid out all the facts that do support the panel's findings of facts. In their brief, they laid out what they believe is the facts that support their claim that that the panel's findings were not supported. And essentially, they're just asking this court to reweigh the evidence. I would cite in Ray Murphy again, 312 Can 218 to 219, talking about that that this court does not reweigh evidence when determining whether the panel's findings are supported by clear and convincing evidence.
No, go ahead.
You're asking us to hold the respondent to a pretty strict standard in terms of preservation.
I am.
Kind of the flip side of that goes to one anomaly that I noticed, and I wanted to ask you about it, which is, at least as I look at the record, your office did not present any evidence at the hearing on the Ewing matter. And does that, if we apply a strict standard, can those findings be sustained when you didn't present any evidence at the hearing?
Well, I would take exception to that because...
Well, go ahead and enlighten me.
Sure. The exhibits that were admitted at trial included the Court of Appeals decision in Ewing, and then plus also transcripts from the actual Ewing trial, talking about witnesses.
So your response would be that in your case in chief, you admitted evidence to the panel on the Ewing matter.
Right, to at least establish, because the two rules that were at issue for Ewing was 3.4E, alluding to matters not supported by the evidence, and then an 8.4D, conduct prejudicial to the administration of justice. And so at least you can make a prima facie case based on the Court of Appeals Ewing decision in addition to the transcripts that were admitted into evidence. It was then incumbent upon the respondent to then come forward and to then explain why.
Is an appellate court opinion evidence in a disciplinary?
I would say yes. It's an evidence that they can consider. I would cite this court's decision in Ray Klein, where in that case the respondent was answering to a disciplinary complaint after two appellate court decisions. In the statement of facts, in the Ray Klein decision, they cited extensively to those two prior appellate court decisions. I would just point out that in the Sherman opinion, after this court defined what prosecutorial misconduct is, it then went on to then give direction to district courts that if they come across any circumstances where in the court's own discretion it determines that prosecutorial misconduct likely occurred, should hold contempt proceeding to determine whether or not the prosecutor did in fact commit misconduct. And I cite that for the purpose of, again, just saying that I believe the main purpose in Sherman, that language, and then also defining prosecutorial misconduct, was for the purpose of giving direction to district courts to then hold subsequent contempt proceedings. And again, that lends support to the argument that Sherman's definition of prosecutorial misconduct should not be applied in a disciplinary proceeding.
Well, I want to talk with you a little bit about that. I think it's clear from the language in Sherman that one of the goals of that language was to make it clear that not every instance of prosecutorial error is also a disciplinary violation, or also misconduct. Would you at least agree with that?
I would agree with that.
So that begs the question, well, how do we know the difference? And you've raised that issue, and that's kind of one of the things that's in front of us. And so I wanted to ask specifically with regard to the 1.1 competence rule violations that were found here. What was the culpability standard that your office argued for and that was applied by the panel?
In closing argument in this case, I was arguing that the 1.1 violation, if the panel decided that she in fact had a reasonable basis for asking Detective Voley about the PFA, then she exercised incompetence by not actually verifying that fact, whether or not there was an order.
And I saw that as well. It seems to me, and I want your to hear your response to this, that the disciplinary administrator was applying what almost amounts to a strict liability standard, where if a lawyer makes a mistake, it's ipso facto incompetence. So it's like any mistake, and we've all either are or have been lawyers, and every one of us has made a mistake somewhere along the way. Did we all commit an ethics violation by being incompetent?
No.
So how do we know the difference?
Because in this situation where she has come across an actual motion she had the motion in front of her, and obviously she was aware of it when she filed her 60-455 motion. For a lawyer to then not go out and verify whether or not an order resulted from that motion. And
so you're arguing the facts to me. I'm looking for an objective legal standard against which I can measure the facts. And again, I haven't heard one yet.
I would say a pure mistake on the part of an attorney would not constitute a violation of the rule of professional conduct.
So it has to be something more. So what is the something more? Is it gross negligence?
I'd say
Is it recklessness? Is it something else?
I'd say at least negligence, as in
Well, every mistake is negligent.
as that term is defined in the ABA standards. Fortunately, I can't.
But you appreciate, I think, the difficulty that a court
Sure.
might have, because we really need some sort of objective measuring tape. And that's what I'm just looking for. Is like, how do I know what's incompetent versus what's just a negligent mistake?
I think it would be having to look at the facts of each individual case to make that determination. And if it shows that the attorneys.
Would you object to a Sherman-esque standard that says it has to be negligence plus?
I would.
Along the same lines, I wanted to focus on the other competence issue which was the statement about robbing children. We see statements like that on prosecutorial error claims very frequently. So to me, it was hard to decide where you would draw the line of competence in something like that, where we've had cases that say, don't say this or stay away from making this kind of an argument, but then we'll see them repeatedly, and often, probably it's just in the moment of the heat of the argument, those kinds of things come out in a fashion that wasn't really intended. Words are out. Probably a lot of times the prosecutors like to reel them back in, but they're out. That type of thing. What distinguishes one of those from ethics violation versus just a poor choice of words in the moment?
And I would come back to the specific facts of this case, where if you look at the amended formal complaint that was filed, the allegations that result to the comment, she also robbed her children of their dad and fiance. In the complaint that I had filed, I also noted that it has been longstanding law in this state that prosecutors are not to make any references to the impact that the crime had on the victim's family. And so I think that if you're trying to judge a particular statement that was made by a prosecutor, then you should look at the case law that has come out determining, whether or not that type of comment is erroneous, and if it's a longstanding tradition of finding those types of statements erroneous, then I think that could lead to finding a 1.1 violation for a prosecutor to then subsequently make that statement in a closing argument.
Matter if the mistakes that are made are surrounded by what otherwise appears to be highly skilled, highly competent representation?
Again, it depends on the unique circumstances, the unique facts. If there was a statement that was made in complete isolation, no other statements at issue in the closing argument, then I would argue that likely, based on the surrounding facts, shows a pure mistake on the part of the prosecutor and would not result in a violation.
I wanted to ask you about, I want to get back to the protection from abuse order, and I'm specifically referring to page 28 of your brief, where you make a statement that says respondent could not rely on Sergeant Voll's testimony to state truthfully to the jury that a protection from abuse order existed. There's discussion in the record from some of the other prosecutors that, this goes to the quality, the fact that he took back what he said about 16 pages after he said it, setting aside whether the respondent should have heard it or not. I understand there's that notion, but there's still this notion of this is about the quality of the evidence, so that it was okay to go ahead and press this point because the detective had at least said it before he qualified it. So what's your basis for this statement in your brief.
Going back and looking at the other facts of how the respondent was acting before the trial and during the trial up until that point of asking Detective Voley that question, makes it highly probable that she knew that that there was no PFA in existence or there was no order that had resulted from that motion. And so I think that statement that was made in that brief needs to be coupled with that. I would point pieces of evidence, again, the 60-455 motion, where respondent only cites the fact that MS had asked asked for a motion for a restraining order in October of 1998. And so that would strongly indicate that she only was aware that there was a motion, that there had been no order that came out from that. I would also cite in that very same motion the fact that she cited an order, an actual PFA order that the daughter, HS, had received from Chandler, or against Chandler in 2009 in Colorado. So that certainly shows that he was interested in finding out whether or not an order had resulted from a motion requesting a PFA in one instance, but in the instance in 1998, she doesn't seek to try to omit the order. She only seeks to omit the motion, which showed, I think, convinced the panel that she was aware that no order had resulted from that motion.
And is the test good faith basis? I mean, is that the test in order to make that assertion at trial?
Do you mean to ask Detective Voley that question about the PFA?
Yes.
Yeah, you would have to have some sort of good faith basis for asking that.
And the source of a good faith basis can come from only the court records or from other sources?
It could come from both. And in this case, the respondent eventually said that, I could not verify that an order had resulted from it. But I talked to family members and I talked to Detective Voley, and they told me a PFA had resulted from that motion. Well, when you then go back and see if there was any corroborating evidence, you look at Detective Voley's testimony at the disciplinary hearing, and Detective Voley said that I never could verify whether an order had resulted from that motion. And furthermore, he said that I don't have any memory, I never told the respondent that I did in fact verify that. So that doesn't support her first claim. And then when you looked at family members, if I was trying to rely on the fact that family members were telling me that a PFA was in existence, I think I would call some of those family members at my disciplinary hearing to corroborate what I'm saying. We had no family members that were called to corroborate that claim at the disciplinary hearing.
Well, how would that help if the district judge in Douglas County made a mistake and just issued the order from the bench but never issued a written order?
We have no evidence of the district court judge doing that, of issuing the order. And going back, there was nobody came forward to say, I believe that MS got an order, and in fact, I conveyed that to the respondent prior to the hearing.
I'm going to take you, there's a lot of issues here, so I'm going to indulge even though you're over the time limit. Back to the Ewing matter. I take it that the panel and your office sort of took as a baseline the Court of Appeals opinion finding error. Like that was, nobody questioned that. It was a Court of Appeals opinion, and that's where that prosecution of those violations really started from. Is that fair?
So the DA 13174 started off as a complaint that was filed with her office by Ewing's mother. While the investigation of that complaint was pending, then the Court of Appeals issued their opinion, and that was considered along with the investigative report.
But as you said earlier, I take it that it's not controversial to say that the Court of Appeals opinion was sort of the foundation of those rule violations.
That's correct.
That were found. So my question, I think this is an interesting, I don't recall this happening before, but the Ewing matter was not appealed to this court, or at least if it was, we didn't grant the appeal.
The petition was denied by this court.
And given that, what if we disagree with the Court of Appeals finding of prosecutorial error? I mean, have we effectively bootstrapped an appeal of the Ewing case, at least as to prosecutorial error, into this disciplinary matter? Or are we sort of stuck with the Court of Appeals holdings?
I think the two issues, whether or not it was error, is a different question than whether or not those.
Well, if it wasn't error, could it still have been a disciplinary violation?
I'd say it'd be very difficult to prove one.
So it seems like it matters.
And so if in that situation, this court would have granted review and ultimately reversed the Court of Appeals conclusions that those statements constituted error, then most likely we would have never pursued a disciplinary complaint.
What would be the right thing? Let's just hypothetically say that this court comes to that conclusion, at least to one or more of the findings of the Court of Appeals. What would be the right remedy here?
I guess the right remedy would be to reverse the panel's findings of
Would we send
violations.
it back? Would we, like, I'm just thinking procedurally, how does that impact this case?
No, because, I mean, in prior discipline cases, when the court disagrees with the panel and they reverse a finding, I mean, if there's ultimately, they don't agree that any rule violations had taken place, then I think it ends the matter at that point.
Well,
There wouldn't be a remand.
so there'd be nothing left, is what you're saying? Like as you said, the mother filed the complaint. I'm just, from an evidentiary point of view, are you conceding that if the Court of Appeals got it wrong, then there's nothing left, at least with respect to the Ewing claims?
I would agree with that.
Part of that was going to be my initial question, but Justice Stegall asked it. It was how the Ewing matter got before you, and that's pretty clear at this point, complaint by the mother and then the Court of Appeals opinion. But part of the problem, or part of what I see, is that there was error by the trial judge, at least found by the Court of Appeals, of allowing certain evidence, particularly the pornography evidence. And once that was allowed, the respondent then took that allowance of that evidence that was admissible and commented on it, used it in ways that maybe violated the rules but didn't violate the rules. But isn't that the problem here, is that there was an admission of evidence that shouldn't have happened? And what do we do with that? It's kind of piggybacking on Justice Stegall, but that to me is not the respondent's fault for being effective advocate for her position, with one getting the evidence admitted and then commenting on it.
Sure. If you look at the statements that the Ewing court found erroneous, there was one that they did that the defendant on appeal raised about, I believe there was some sort of statement about the pornography, not necessarily the one about autism abuse, but there was another comment about pornography, which the Court of Appeals panel said, because the district court had admitted the pornography, we're not going to find that it is erroneous that the respondent commented on that. And so that was not found in error by the Court of Appeals, and that was not pursued any further by my office in prosecuting DA 13. So I think that the other, even ignoring the fact that the pornography was erroneously admitted, when you look at the other statements, those statements are not directly connected to that erroneous admission. And so you can still find that they're error despite the fact that the pornography evidence was admitted erroneously.
Are we looking, I mean, I guess this particular, this one didn't get me too animated in terms of, I understand what you're saying is the Court of Appeals said there was prosecutorial error because these statements were made and they're not supported by evidence. You come into the disciplinary hearing and say, here's the evidence. You can match the evidence to what the Court of Appeals thought there wasn't evidence for, and then decide whether discipline is appropriate. That's all I thought was involved here. Am I missing something?
That's basically Justice Biles. I mean, again, the respondent could come forward with evidence to explain.
I mean, that's why you have the hearing, and everybody gets to fight over, whether, but there's nothing conclusive other than the Court of Appeals said the evidence didn't match, but now everybody's got a chance to argue about whether the evidence matched the statements. It's a do-over, in effect.
Essentially, yes. I mean, basically.
Within the context of disciplinary violations.
Right. Okay. I mean, I kind of seen both of these cases when they ultimately involve appellate decisions that we basically know what happened, and then the disciplinary proceeding is to determine why it happened and whether it rises to the level of a violation of the rules of professional conduct.
Well, just a quick follow-up there. Earlier you said, I think, that the only evidence that you presented, that your office presented, on the Ewing claims were the transcripts and the Court of Appeals opinion.
Correct.
That's all we have to go on. Or that's all the panel had to go on, right?
The panel also then considered the evidence that the respondent.
Sure, the defendant had, or the respondent had additional claims to rebut that, but your office didn't put on any additional evidence.
Cross-examining the witnesses that the respondent put forward to support the claims in Ewing. No further questions. I will address the court during my rebuttal time.
Mr. Leatherman?
Chief Justice Lukert, members of the Kansas Supreme Court. Practice of law is an exercise in extreme trust. We must be able to trust our judges. We must be able to trust our lawyers, because otherwise the entire system would shut down. 4 years ago in Chandler, this court heard the arguments of my client, Ms. Spradling, and at least 3, if not all of the justices, seriously doubted the veracity of the statements by Ms. Spradling. They said, Mrs. Chandler's conviction cannot be upheld because there is error, and we deal with people's liberty, and we deal with people's property. We will take neither if there is error, regardless of intent, because it is that important to us. And they sent the question back to the district court of the trial of Ms. Chandler, and that is on its own path. And you sent an inquiry to the Office of Disciplinary Administrator and said, you need to determine, because we don't have the universe of facts. We only have the appellate record. We don't know if there was malicious intent here. We don't know if there was an intentional misleading of a district court, intentional misleading of a jury, or whether due to the circumstances and context of the activity, this error was produced. And an investigation commenced. What this court didn't know, but knows now by the record, there had already been a complete investigation of Ms. Spradling's conduct due to the complaint filed by Ms. Chandler. That was conducted by the lead investigator for the prosecutorial committee of the state of Kansas regarding the conduct of prosecutors. And the findings of that investigation were that in the context of how this arose, Ms. Spradling operated as lawyers operate and as judges operate. And that is, we trust the process. We have to trust the process. The disciplinary administrator makes a very big deal that she didn't go physically over there and touch the order herself. No trial lawyer touches the evidence themselves until someone brings it to them. Because we have to trust witnesses or we become witnesses. We have to rely on witnesses to bring us the truth, and we have to follow up on that investigation, and then we have to present that evidence, and then we have to show the instructions that our arguments are not evidence, but merely our belief as to the evidence. And that's what Ms. Spradling did. And what tragically happened in that courtroom is that Ms. Spradling filed her motion. In response to that motion, defense counsel identifies an October 1998 PFA. In ordering allowance of evidence, the district court judge, Ms. Parrish, identifies the order again and discusses the applicability of the rules of evidence. Now, 3 people believe an order exists. And that's why what was very important to the investigation and ignored by the panel is that we brought Judge Parrish into their chambers and said, Judge Parrish, please identify if you were misled. And she said, I was not misled. I am the one who wrote that into the record. I feel horrible that it was written into the record. Once it was there, there was a universal truth among these 3 people that that order existed. They were all 3 wrong. And in being wrong, they referenced it, and Ms. Spradling referenced it because she believed it was true. Which goes to part of the closing argument of the respondent, or excuse me, of petitioner in the proceedings. It's the deposition, or the trial transcript page is 1095. I apologize, I don't have the record on appeal, but it's the closing argument. I want to move to the 5-minute phone call in the Nebraska trip. The disciplinary administrator's office does not dispute respondent truly believed before and after the Chandler trial the evidence. If she truly believed it and she was wrong, how can that, to your point, be a disciplining sanction?
Let me take you to a different
Yes, sir.
place. I was struck by the bottom of page 5 of your brief, which says, the first indication there was a problem regarding the PFA was at oral argument. And I assume that means the oral argument before this court, right?
Yes, sir.
Okay, what do you mean by that?
That lawyers brief issues, and we think we know what the evidence is. We believe this is what we got in. The brief was done by Jody, and I apologize, she was just here.
Litfin.
Thank you. Jody and my client, Ms. Spradling. And it's the way all of us as lawyers work, and I don't know how judges work, but I assume it's somewhat similar. We trust other people to help us with projects. And Jody reviews, Ms. Lifton, reviews the record and helps put together the facts, and Ms. Spradling looks at the facts, and we're making our arguments, and Ms. Spradling believes, as I believe should, that the evidence of the testimony of Detective Boley is the evidence of the order. That in the record, there's evidence of that order by his testimony. Weight and credibility aside. She believes that, and she's going through it, and therefore Ms. Lifton believes that. And as they believe that, they write their brief, and it's responded to, and they think, well, that's interesting that they say there's no order, because Detective Boley...
But let me tell you, when I saw that sentence, what I did was go back and look at the defendant Chandler's 2015 opening brief. Mm-hmm. And there are 8 separate places in that brief where it says there's no PFA in the record, that the detective took it back. There's even a paragraph in there that recites the detective's testimony, saying, I can't remember if there's really an order. Go look in the court file. I mean, that whole thing that we did at trial.
We've read it.
So how can the respondent not know, coming into this court where there's no heat of the moment, there's plenty of time to prepare, you get up here, you do it. How do you not know that you got a problem with whether the PFA really exists or not?
It's because of the way the human mind works. And if you believe something's true, you don't worry about it being untrue. Of the multi-million Christians in the world believe the 10 Commandments exist, and none of them have seen them because they believe they exist. And once you conjure a belief in your head, you don't question that belief. It's not the way the mind works. Mrs. Spradling thought it existed. There was no reason to go look for it because she believed it existed. And in looking at the briefs, the detective fully testified to it.
But then he took it back. I mean,
I
knew we can quibble over that, but the detective said what he said.
Yes.
And to me, it's unbelievable that if I get a brief from an opponent that says, you know, that this piece of evidence, which, you know, was so important that it garnered 2 PowerPoint slides in the closing.
I believe out of 32.
How do we know this person's guilty? Because this PFA order exists, and the judge, if that's what's going on, and I've got the other side telling me this thing doesn't exist, the first thing I do is attach it as an exhibit to my brief saying, okay, next issue. And they don't even talk about it in their reply. They just blow right by and says, oh, well, yeah, it's there.
Exactly. Two responses to that and a better answer to your question about why didn't she do that and why did she believe it. And that goes to the trust issue. She is with competent trial counsel and competent defense counsel. And in that trial, that defense counsel doesn't raise that it doesn't exist. Why didn't he know it didn't exist? Why didn't the judge know it didn't exist? Because all of them were wrong.
I mean, honestly, he cross-examined. The detective gave him the answer he wanted, which I don't know if it exists. Go look at the court file, and of course it's not in the court file. So that's how Mr. Bennett, you know, gets what he wants out of the trial. And I get back to, you're coming into this court, standing, different carpet, but standing in the same place you
right.
are. And when we ask, there's no PFA. Oh, yes, there are 2 of them, you know, in the record, and one's October of 1998. And the briefs from the other side have given all of the details.
Right.
I just don't understand how, especially competent counsel, and one of the issues is competence,
right.
how competent counsel can make that representation that was made in front of this court.
And I understand your disbelief. I don't think she can go get the order and attach it as part of the appellate record because it's not part of the record. The question isn't for her, is it in the record? And she said that day in those arguments, I don't want to mislead this court. The actual order is not part of Exhibit, I believe, 969. It's in the record because the detective testified to it. And they want to say, well, he later said, I'm not sure. You'd have to go look. And then it was that probably 18 seconds of a 3.5-week trial. She's not allowed to bring evidence in front of you that's not in the appellate record. So I don't know that she could attach it. I don't know that it would be appropriate that she did or attempt to.
I think, you know, when we have arguments in this court, and we had them twice this week,
yes,
where lawyers either identified that they were going outside the record for a second to tell us something, wasn't important, but going outside the record. We had another lawyer file a thing saying, I misspoke during oral argument.
Okay.
And so, you know, just want to be clear. None of that happened here.
The post-argument, all I can say is I agree with every person here that we can't have lawyers that we can't trust in our system because it's too important and too valuable, and it is literally the gold standard that we must abide by. But that the record here does not show dishonesty or any intent to mislead. It shows that a horrible, horrible thing happened, and that is there was a very specific item that they got wrong. But that cannot be the standard for the practice of law, to your
counsel,
point.
let me ask you
Yes.
about that. There's a lot going on in this case.
Yes,
but
sir.
I think everyone would probably agree that the centerpiece is the PFA and whether or not the respondent lied about the PFA. I mean, that's the centerpiece, at least to me it is.
It is.
And there's a lot of time spent arguing about that. and you make an impassioned plea that Ms. Spradling might have been wrong and might have even been incompetent in that wrong belief, but it wasn't a lie. And so my question is,
Yes, sir.
what are we supposed to do with the fact that the panel made an express finding that it was a lie, that the respondent intentionally made a false statement to these various tribunals? And I guess I'm searching for what is the standard we weigh that panel finding against? Because it seems like it's really close to just a flat-out credibility determination where the panel says, we saw your client, we didn't believe her.
I think it is more than that for very specific reasons. And to address your first statement, that I argue it is either a lie or incompetence, I argue very differently than that. I argue that very competent counsel, trusting a very competent judge, made a horrible mistake, and that's not incompetence. It's a horrible error.
I didn't mean to say.
And I just didn't want to leave her over there going, why didn't you defend me, right?
No, your primary argument is it wasn't incompetent at all.
Wasn't
but there is a distinction between making a statement that turns out later to be untrue and just doing it without the proper level of competence versus intentionally telling
intentionally. That in this particular case, but in all cases, what I'm asking you to do for Jackie Spradling, for the lawyers of the state of Kansas, and for the integrity of this institution, is to read that record and see if I'm correct. Because it's deference to the panel, but not binding. Your hands are not locked. And we cannot say, with good conscience, that Mrs. Chandler's liberty was so important that although this might not have been the reason it was overturned, we can't take that risk and take her life. I want that same passion to be done with my client, Ms. Spradling. That a license to practice law is too important to be caught on some technicality that you and I and us and we know.
Hold on, I'll just interrupt you. I'm sorry to interrupt, but I mean, whether or not the respondent lied is not a technicality. And
I agree with
that's
that.
what I'm trying to drive at is the panel says to us, the panel writes a report, they hear all the evidence, they say to us, this respondent lied. I mean, I'm shorthanding, but that's effectively what they say.
It's much like to the jury. We are prohibited from saying they're lying, so they didn't say that.
Well, they said that she intentionally told untruths to the tribunals. And so
the technicality was not that she's lying, sir. And if that was the impression, then I did a poor job of explaining my position.
No, that's okay.
The technicality is I don't believe this court will write a decision that says after review of the record, it's clear Ms. Spradling did not lie, but our hands are tied. We must defer to the panel.
Well,
I don't think you would do that.
Our standard of review is the panel's finding. This is a finding of fact, and is it supported by clear and convincing evidence?
Yes, and I don't believe it is supported by clear and convincing evidence.
Just can you give me a summary of an articulation of why the panel's finding is not supported by the evidence?
Number one, there's no witness in anywhere. The Henry Klein, there was a witness that came forward and said, I told him he shouldn't have done that, and he told me he didn't care, something to that effect. There was evidence that he intentionally misled this court or courts. In this case, there is no evidence that Ms. Spradling ever identified to anyone that she meant to do it. They have investigated Mr. Chadwick Taylor. They have investigated the court reporter. They have investigated Mr. Foley did not say, I talked to her, and I said, whatever you do, don't say it's real because it's not real. That kind of evidence would indicate that someone identified to her that it wasn't real, and she made it up. There's no evidence. There's no evidence in the record. There's no evidence outside the record.
Would it be a fair summary to say that your argument to us is that a panel's credibility determination by itself is not clear and convincing evidence of a dishonesty?
That is
something else.
There's got to be something more than that. There's got to be something in the record, and Hanlon's razor, and Occam's razor. The simplest explanation is always correct. What is the simple explanation here? That she made a mistake. The conspiracy of malice and implied malice to a lawyer is inappropriate. Where's the malice? And 6455 motions, you hear them all the time. And in hearing those, why do we have 6455s? Because people don't just kill people. They've got to have motivation. They've got to have reason. Mrs. Spradling is a nationally recognized prosecutor. She did not need one more murder conviction. She has 80 standing murder convictions. She didn't get any money from it. She didn't personally know the defendant. They say she's just went crazy and did this. If she went crazy and did this, are there 81 other crazy cases out there? She did this and made a horrible mistake. As Judge Parrish put upon the panel, I feel horrible. I made a horrible mistake. I identified in my order the PFA of October 15th, 1998. I mean, everyone there thought it happened.
You know,
We have no evidence now that it did.
Interesting to me that you want a more direct evidence standard to apply to Ms. Spradling in a disciplinary case than the circumstantial evidence that exists against Ms. Chandler that's beyond a reasonable doubt. That's a circumstantial case, too, and there's all kinds of inferences that you try to rely on.
Not me, but I understand what you're saying.
You rely on to try to explain some of the things that the respondent said at trial and before this court. That's my point. Let me ask you about the 5-minute phone call. Because it seems to me there's a contradiction between statements that were made. When the respondent was here and Justice Breyer was pushing on...
May I get some water?
Sure. Was pushing on the 5-minute phone call, the respondent, again, stood right there where you are and said, we know exactly what happened in that phone call. In your brief, you say, oh, here's a little fact, and so we can infer what happened in there. And the panel did not believe the rest of the evidence that you had, the individual that put that in there. So my point is, again, the representation to this court, where we expect candor,
yes, sir,
was that the evidence shows exactly what happened in that 5-minute phone call. That's what was said. And that's not true. And if I couple that with the PFA, I start getting a little more circumstantial evidence about intent.
Yes. Let me address...
I'm not trying to go. I'm just trying to say this is the same kind of accumulation of evidence that you process in any kind of case.
I appreciate your sharing your thoughts with me versus holding back and sharing them back there. So don't apologize. The statement made by Ms. Spradling, we know what happened in that. She knows what happens because she interviewed the person who told her what happened. She knows what happened. She interviewed the witness that told her what happened. Due to a hearsay exception, it could not be put into evidence. And that's well documented in the record, that Judge Perry said, no, that's hearsay, so we're not going to let him testify to that. So then she puts in the dots of other evidence that she has and makes the argument to the jury, and we now know, I mean, I watched the previous argument, you can't say we know, and so the argument should have been different, that do you believe that that 5-minute phone call is when she learned? Do you believe, what is it, by the garage or by the carport conversation that took place much earlier? Inartful, as was reviewed by the New York prosecutor in this case, inartful but not intentionally misleading. It simply isn't there. It simply isn't there. There's no there there. There's no smoking gun. There's no, and there's an explanation, which just for a moment going to Ewing, I don't believe you can just put in a court of appeals case and then shift the burden to my client to defend her license. I don't think that's appropriate. The respondent does not bear the burden of proving they're innocent. You must first go beyond a prima facie case. You must give us clear and convincing evidence that it occurred. And laying a court of appeals decision, and by the way, that case too was investigated by Ms. Kim Parker, who found no probable cause to proceed. And we have two prosecutors who spent over 60 hours who went looking for intent and found none. But even after that, they argued desperately not to let those prosecutors testify, not to let their reports in that there was no probable cause. that the substance of this record is devoid of that intent. And I understand that there may be a tickle, a thought, that maybe that's not clear and convincing.
Those people testified before the hearing, getting back to Justice
Yes, sir.
Stiegel's notion, those people testified.
They did.
And the panel made the findings that they made.
Right. It does not appear when you read the panel's decision and you review the record that they match. It's as if the hearing, other than Mr. Kite, but there's no mention of the federal agent who went through the metadata to determine that those documents did come from Mr. Kite. Jackie did not bring those documents. They were from Mr. Kite. They found none of our witnesses to be credible. They found none of that, and they accepted the Court of Appeals decision. I think the mission is, can we put trust and faith in Ms. Spradling? And did they prove that she lied to you? And I don't think it's there. The record just does not support, by clear and convincing evidence, the recommendations of the panel. It absolutely does not. It is not in Ewing, because there is no evidence in Ewing. How can it be clear and convincing when it's devoid of evidence? And if they got that wrong, and we need to go back and understand what our mission is here, if negligence can be disbarment, none of us are safe, and it can't be the standard. We can't imply malice. We can't presume malice. She could not bear the burden because we could not bear the burden of proof in defending ourselves. That is their job. And they didn't do it because it's not here. They did a fantastic job. They did everything they could, and there's just no there. And it's remarkable. But we have to, whatever you decide, and we can't say this to juries, but we need to know what the standard is. And you know that yours will be read. That we have to define this thing. And we have to say, okay, if just because there's a bad result does not mean that there was malice. It just doesn't. You can't presume it. And that's the way they treated that. And that's the way it was presented to the panel. I mean, look how horrible this was. And I think, look how wonderful this worked. Because why are we here? We're here because district courts screw up, right? We're here because appeals are necessary. We're here because we absolutely believe in due process. And Ms. Chandler will get a new trial because you guys did your job. You did it. You did a fantastic job. You held her feet to the fire, which is your job. You held her feet to the fire, and she made a horrible mistake, and Ms. Chandler gets another trial, and justice will proceed. If we start disbarring prosecutors because they get it wrong, what's her choice? Don't prosecute it. Don't appeal it. Whatever you do, don't argue your own appeals because you're corrupted with your personal knowledge of the investigation and with the record, and all that meshes. And you say things as silly as we all know. She thought we all knew because she knew. And she's got to be more careful with that language. And that upset people. And for those of us who are nerds and listen to this on podcast, I knew when she said it and the questions began that someone would be standing at this podium for Ms. Spradling. I didn't know it'd be me. But she violated your trust. You felt very sure that she did, and you did the right thing to send it back to ask that question. And there's just no there. All the people in that district courtroom believed it was real. They did. The officer believed it was real, and if you want to put it your way, and then didn't believe it was real, but it really was in the record. And that's how trials work, and they're nasty. And they're hand-to-hand combat, and they're 3 weeks long, and they're 38 slides. And if she had it to do again, she got distracted by the shiny object of the order. She's like, oh my goodness, now it's in the record. I will talk about it. If she'd have left it alone, we wouldn't be here. But she thought it was important in that moment because it made it into evidence because someone testified to it. And if we can sanction lawyers for making arguments about evidence that's allowed by a district court, that's later determined it shouldn't have been admitted or later determined to be wrong. We cannot Monday morning quarterback prosecutors in this state. We can certainly correct the error by giving the defendant another trial, and must, if our creed is true. But we cannot then turn that and say, here's a Court of Appeals decision that she made error, make her prove she's not lying. What message is that to prosecutors, to lawyers, or to this institution? It's just wrong.
Counsel, can I?
Leatherman?
Yes, sir. Ma'am, I'm sorry.
Just real quickly, I don't want to delve into the legal arguments because I understand them on the polygraph issue. But if your legal position prevailed, how does that affect our assessment of the findings under the clear and convincing evidence standard?
Just as well, I'm going to be honest, I don't quite understand your question.
Okay, so the polygraph evidence that was excluded, if you were correct legally that should have come into evidence, what do we do with that?
I'm not sure, and I think my beginning position about error and incompetence starts with my brief. I noticed it yesterday in preparation for today. I put an appeal from the hearing panel, and it's not. It's a original in the Supreme Court to explain my answer to your question, and that is, I don't know how this works, because does double jeopardy thoughts apply in this? That Ms. Spradling has been with this for 6 years now, because the investigation from Chandler began 2 years before your. Is it finally over? And you say, look, they blew it. They didn't apply the right standard, and therefore Mrs. Spradling goes free. I don't know. I don't think that's what you're going to tell me. If you say it was done wrong because the veracity of her statements is at issue here, and it should have been evidence that mere negligence, he's wrong, isn't the standard, and it's not binomial, it's either evil or incompetence, we brought back what happened. The constellation of facts are horribly, and the district court judges on this great court know, they've sat there and they've watched the blood and guts of trials. It happens, an error was made. We'll go back and fix it. I don't know if you send it back for them to do right. If there's enough evidence, I hope, for you to say there's no there. I'm not sure. It's kind of like the Chandler decisions itself. They were kind of, okay, now we're upset about this, and we're going to reverse this, but courts generally don't give, and y'all did better than I do. That's why I'm on this side. There's a rule that you just don't give opinions that aren't central to the issue. I guess it depends if it becomes central. I think it's appropriate that they should have considered those results, and our polygraph should have been allowed to, a technician should have been allowed to testify. But it's the crazy part of this being an original proceedings. It's in the record, right? It's in, it's out. It's that same thing. We all know there's a polygraph. No, we don't. It's not in the record. And we know she passed it. So does the fact that they didn't, can you use it, right? Rule is you guys get to do what you want, and then there's rules, but are you considering it? Well, we're talking about it, but it doesn't exist. Yeah, I think it should. I think for purposes of structure, it would be nice to know if I ever have another client in this situation, what we should do. But I'm not sure procedurally. You can't remand because it's here originally. Go back and I don't know. I just think what's happened at this point is not, because your review is it supported by the evidence, and it's not. I know it's a great deference, but I know you will read the record. I know you will read all the record. I know you will study it hard, and it's not there. Yes, ma'am.
My question
Yes, Your Honor. I'm sorry.
goes back to the PFA
Yeah.
issue as it evolved through the various stages of the process. And in specifically the panel's final hearing report, it's paragraphs 137 through 140 that I'm focused on.
Okay.
And they are looking at Ms. Spradling's sworn statement made during the investigation. And they reached the conclusion that she eventually concedes that she made a misstatement in that sworn statement, and that she explains to them that she misspoke and was wrong, and made a mistake in not asking to look at the file. Mm-hmm. And they conclude that all rings hollow to them when it was made during a disciplinary investigation, 2 months after the Supreme Court overturned the Chandler conviction. I would just like for you to kind of address that, either you or your client, as to how we can reach a different credibility determination, really, over the panel who listened and heard that and weighed that evidence.
Everyone here I think most of the people here have either been in the district court or this court in front of my client. She's a deeply passionate, devout believer. And as a devout believer, she is sure and certain of the facts in her mind. She does not question her mind, and that's part of being a trial lawyer. That it's whether you're Mahomes on the football field or Brett on the baseball field, you must have a short memory and be convinced you are the best, or you cannot play at this level. And when you prosecute first-degree murder cases, you have to trust your mind. You can't second-guess your mind. You do the research, you do the labor, you do the work to find out the truth. And then once it deposited in your brain, you do not retreat from it. And at the time that statement was given, she earnestly believed that order existed. Oddly, I believed it existed. She earnestly believed it. And it goes to that point that when people truly and believe that this is what occurred, they don't question their mind. And there was no reason. She was no longer with the district attorney's office. She was no longer assigned to the case. She had been reversed. She doesn't have access to go look. And she thought, it'll be there. It'll be there. I know it'll be there because I know it exists. And the mind does that. That's the way the brain works. It's the way all of our brains work. Why do I feel confident standing here? I think I know everything in that record. And we're talking about it. And if I would second guess myself, I might be wrong, but I'm not unsure. And that's the way trial lawyers work. And everyone here that's been in trial courts knows that about trial lawyers.
But Mr. Leatherman, if you apply that same standard to judges, then why would we ever entertain a motion to reconsider? I mean, I remember, when I was a Court of Appeals judge, my second or third year, I got a motion to reconsider because the party said that something in there was wrong. In my opinion, was wrong. And I read it, and that was right. It was wrong. I did the research, based on the motion to reconsider. I did the research. It was wrong, and we issued a modified opinion. I mean, so you're asking, wouldn't you ask that of the court?
I believe I understand your question, and I hope I answer it properly. Your hypothetical, as presented to me, is if Ms. Spradling had an opportunity to do it differently, why didn't she do it differently? That opportunity only arose after she figured out she was wrong, and then she didn't work on. She was not appellate counsel that left to Ms. Jody Lifton.
Whose name was on the brief to the Court of Appeals?
Ms. Spradling's name was on the brief. She thought she was right at that point, and that's why I say she didn't know she had a problem. She was way too sure. I assure you, she's not as sure in herself as she was. It was an absolute heartfelt belief that it was there.
But would you hold me to the same standard, that I had a heartfelt belief that I was right in my opinion, so why would I even read? Because Justice Biles said that in the appellant's brief to the Court of Appeals, they brought this up.
To us. This is our court in the Chandler case.
Oh, okay. I'm sorry.
Yeah.
I apologize for that.
It was
a direct appeal. So brought it up to the Supreme Court in the brief, but she didn't, you're asking, I get my bottom line is, are you asking to hold a prosecutor or any lawyer to a different standard than you would judges under the Judicial Code of Conduct?
No, I'm explaining why it's important that we show grace and why we understand that this happened. That she should have She should have done it differently. I don't disagree with that. Whether she should be disciplined with disbarment for stubbornness versus malicious intent is something different. I'm not saying, and she should have done it the way she did. Knowing what we know now, that question should have allied with Ms. Lifton. That should have allied in her mind, oh, we should. And by the same token, there seems to be a disagreement between us and the ODA, and I don't know if it's between y'all and me. It was in the record. If someone testifies to it, it's in the record. And that slight distinction in how what I say is in the record versus what I know you meant, Justice Biles, when you asked the question, because I heard it as it was cast. You meant the physical order. And I could see her brain going, it's in the record. She didn't say this out loud. Where you should look in the record is Sergeant Voley's testimony, and then we could have had this discussion about, does that make it in the record? Based on my knowledge of evidence, that's in the record. And so she's misled that testimony is sufficient. And when it later turns out that the order doesn't exist, now she realizes that was wrong.
The interesting thing to me, and I know we're over time, but the interesting thing to me is that on the second round of oral argument, when it was Miss Lifton arguing, she didn't try to come in and say, well, you know, it was okay for us to say that order existed because the detective said it right before he took it back. They didn't make that argument.
After listening to the first argument, I wouldn't either. But that was
They said it was prosecutorial error.
Yeah.
And then they tried to explain it by saying, oh, she was confused, you know, the big record, all that stuff.
Right.
I mean, I can't recall a case where we've had to work so hard to get to to get to the truth in the record.
Right.
And so, we have that too, that the state gave it up and then started arguing about prejudice. And I don't understand why when the appellant laid out at eight different times why that order isn't in the record and highlighted the detective's testimony, why the state didn't come back and say, oh, you're right, it's not in the record. But we got this detective that said it. And here's why we could rely on the detective even though, he took it back. And quite honestly, when I see that as prosecutors trying, if that argument had been made, that's prosecutors trying to say it's okay for us to walk through a wrongly opened door in order to convict someone. This is a big deal.
It's a very big deal. It's a very big mistake. But at the end, it was simply a mistake. And that's what the facts of this court sent back the request, please go find out what happened. And what happened, according to the district judge that was there, a respected and distinguished district judge, is that she thought there was an order because the defense counsel raised the order in his response to Ms. Spradling's motion. And that in her order, she identified the October 15th, 1998. That's what happened. It's tragic. It's terrible. But if we all believe it's true, no one questions it. It's a deeply held belief at that point because the Honorable Ms. Parrish believed it. The distinguished defense lawyer, Mr. Bennett, believed it. My client believed it. And once that was the collective belief, it wasn't questioned. And it should have been, but it wasn't. But there was no malice. And there was no overzealous prosecutor. This was a 3.5-week trial, a double homicide. The children were called. The detective work. It was 10 years old. This was grinded out trial work. This is what real prosecutors do in the real world to take care of real world problems. And this mistake happened. And once it happened, she lost all credibility to this court. And this investigation needed to happen. She needed to figure out why it happened. She needed to figure out why she was wrong. But she was simply wrong. At the beginning and the end, she was simply wrong. And because...
And in the disciplinary investigation, when she had a chance to set the record straight, files a sworn statement that misstates it again, and the panel makes the point that she didn't take any steps to amend that statement, and in fact filed an errata sheet of corrections without correcting it.
Let me clear that record up a little bit. In an unprecedented fashion, the ODA demanded that she be subject to a deposition. And that was taken, as I think you indicated, 4 weeks after the decision was held down. And we said, we don't want to do that now because we don't have the record, and we're relying on her memory from 10 years ago. And they said, we don't care. We want it now. And they took it. And I thought it was a bad idea then. And I don't know what I had to make, and I am, as her counsel, maybe I committed malpractice. I don't know what we do over there because I don't need a finding that she failed to cooperate. I mean, she has no procedural protections at that point because they said, if you don't do it, we'll force her to do it, and that will be her failure to cooperate with the investigation. I don't need that in a record. This record's already complicated enough. And so it wasn't Jackie gave a sworn statement and sent it to them. Their investigators, Schoenfeld and the other guy, set her for a 4-hour deposition. She was not prepared to give it. She did not have access to the record at the district attorney's office. She had not touched the file since 2018, or whenever her original oral arguments were. And she was relying on her memory. She told him what she believed at that time, and I always thought that was an interesting spin on that statement because they're saying that her continued belief is another violation. I mean, she was wrong because she was wrong because she was wrong, and she was wrong again. That's not misleading them. They asked what she believed, and she told them. And she believed that's what we'd be able to prove. Turns out she was wrong. And once she figured out she was wrong, like I feel terrible and now that she understands it, why she asked the same question that you do, Justice Biles. How did I do it? LJ, how did I do it? Why was I so confident? She was so confident because everyone else believed it. And the fact that other people object to my evidence or say I didn't get it right is part of the battle of appellate and district court work. So it doesn't surprise me that she didn't check because she was confident in her belief. And she was hoisted on her own petard, right? And it was bad. But the confidence of a trial lawyer regarding these kinds of things, and if she would have gone, what would she have done? I would have went and read the record. And if I read that record, somebody testified it's there. It's not sneaky or anything. We thought it existed. It came in. It's there. But trial lawyers, and I went to this a little bit in the beginning, trial lawyers don't like to touch evidence because I don't want to be a witness. And as young trial lawyers, we learn this. So I used to, there's an auto accident. Okay, I'm like, well, there's witnesses, so I go talk to them. And I say, hey, sir, what happened? Well, that other guy, he drugs, blew up your guy's car. Great. Okay, thank you. Bring him into the courtroom. I say, sir, what happened? He says, I don't know. I don't see anything. And I say, no, remember when you talked to me, you told me these things. Now I've become a witness. We send people to get evidence, and we rely on those people to tell us what the evidence is because we can't take the stand. So if the officer that I've worked with for 10 years says there's an order and later says I'm not sure, I believe him the first time because I have ultimate confidence in my team. This does not happen in a vacuum.
How do you have such strong confidence in your team when your team says a few minutes later, after saying the first thing that you want to hear, says, I don't really recall that, and by the way, the answer is in a paper file right over there.
But it's not in a paper file right over there.
Of course not, but that's what the witness said, and if you believe the detective, then you've got to also believe that it's in that file. And if you go look in that file and it's not there, you've got to think that through.
Well, you do now, but in the middle of a trial, it's in that file over there. Okay.
You've got to keep thinking it through all the way through the appellate process. I mean, this is not a heat of the moment
Not at all.
analysis.
It wasn't heat of the moment. It was confidence. She was confident she was right, and it turns out she was wrong. If the order would have been there, would that make the detective wrong? If the order was actually there and he said, I don't know, is that she, along with others, believed it existed and didn't go look? We don't search for that which we know exists. We search for that which we don't know.
A competent lawyer going in front of the Supreme Court of a state, when one side says this thing isn't here, goes and checks the record to see if it's there or not.
And the record, I know we don't like the evidence, and I know we want to say, because it turns out there's no order. Why did you believe the officer? Did you believe him the first time or second time? She believed what she heard and never questioned it. Because she's confident, because she's a trial lawyer, because it happens. But it happens for a much more important reason now that I say that, and I meant to say this now. Because Mark Bennett didn't say there's no order. He didn't object. He asked a question.
The appellant at appeal said there's no order.
Yes.
That's my point. Let's just keep the discussion at the appellate level.
Right.
The appellant's lawyer says both in the opening brief and in the reply brief.
Right.
In fact, in the reply brief, she says, I can't understand why these guys are saying that there's no order. And then she says, if I'm wrong, I'm mistaken. I mean, she tries to put it on her. But we don't get that from Miss Spradling. We get, yeah, it's there.
She was relying, her reliance was on the officer.
And my question is, does a competent appellate lawyer do that?
Yes.
Even when
I do
the
it every
other
day.
side says that they took it back.
Yep. I do it every day. Because we're not perfect. I make mistakes. If I think it's true and I'm not scared of it and I believe it, I don't recheck it. And it's part of, that doesn't mean it's right. And if you're wrong, you end up here and end up in this argument. But she believed it was in the record, and what she saw was the officer's testimony. That's insufficient, and we know that at this point. But she didn't know that at that point, and it was wrong for her not to go look. I didn't mean to say, well, that's okay to do that. I mean that it happens. As competent counsel, you make errors. And I didn't review everything because I think I know it. When you stand here, you have to believe you know the record.
This has gone on a
Yes,
long
sir.
time.
Yes, sir.
But I
yes,
want
Your
you to-
Honor. I'm sorry.
It's fine. You keep on talking about trial lawyers, lawyers. We must also keep in mind that this is a prosecutor.
Yes.
Prosecutor who, at the outset of the Chandler case we highlighted, is not their obligation to win, but it's to seek justice.
Yes.
And do we measure that obligation, that sworn duty of a prosecutor, differently than we do when you talk about trial lawyers or combatants? They do this, they do that. Shouldn't that always be what a prosecutor is seeking, is justice? And this win at all costs, this exaggeration, this entrenched in this memory that she has, how do we look at that in light of what is the obligation of a prosecutor and the duty of a prosecutor?
This is where you look at her record as a whole. This appears to be, and it was said, I believe, by this court, and I know it was said it was quoted again by the panel, this win at all cost mentality. Where is the evidence of win at all cost mentality? She has 30 years of prosecutorial success. She has 80 convictions. She is a
What about not questioning something that's in your mind? I mean, you kept saying, she believed it, she believed it. I never question once I believe it.
No, not that at all. If someone triggers, in the questions you've asked me today, I'm confident in my answers, right? And And so I doubt that I go back and look at the record. I think they're wrong. They think I'm wrong. One of us is going to be wrong at the end. There's always somebody wrong about the evidence. In her mind, and she's here, I guess, if you want to ask her, but in her mind, she was right. It's not that she never questions anything. It's not that she does the opposite of that. The record is replete that before trial, she goes through every witness with notes. She writes out all of her questions. She tells them what she's going to ask them. She's very, very, very competent. She's very, very successful because she's very, very detail-oriented. And when you do that, and you work and work and work, you become confident that you're right. And she believed that the transcript said whatever it said that gave her the confidence. And she should have done the inquiry that was done later. I'm not saying she shouldn't have done it. I'm just saying it wasn't malice that she didn't do it. It was confidence that it was there, and we all see arguments and briefs that we know they're wrong and I'm right, and then all of a sudden the example that we use in trial that may help make my point tighter. Do you know where the arrow is in the FedEx logo? The E and the X form an arrow. And you will not be able to not see that arrow for the rest of your life, because once you see it, you see it. Until you see it, you will have walked by it for how many days you were born until today. But when you see a FedEx truck later today, there will be an arrow, a very distinct arrow made up of the E and the X. And you never saw it. And because you never saw it, you never worried about it. And if people talk about the FedEx arrow, you wouldn't know what it was. But now you see it. That's the way the brain works. She didn't see it until she saw it. And now that she's seen it, and now that we all know that we can't prove it, it's changed. But it wasn't that she didn't care and didn't go look. It's not that she had other things. There were other cases. There were things going on. She read it, and she believed it, and she felt comfortable and safe, because if there was any doubt in her mind, she'd have went and looked. I mean, it's really this weird kind of thing. It's not that we give her carte blanche not to check records. It's on this one detail in 30 years, she didn't go check it. And now we're sitting here debating, was her failure to check that incompetence? And my statement is, no, it's not incompetence. That doesn't mean it was right. Is it intentional misconduct? No, there's no evidence of that in this record. Is it somewhere between?
I have a narrow question to that. There's been some discussion concerning Detective Volley's testimony. Mm-hmm. Testimony can be evidence. Mm-hmm. Also that he testified to the order, but then took it back. Is that what happened? Did he take it back?
I don't think he took it back. I think he was unsure, and it wasn't pursued by defense counsel at that point. And that's the other thing that's going on here, is that very competent defense counsel lets this lay if he knows there's not an order. And how could he not know if there was an order or not? He believed there was an order, and the question, did you see it signed? No. And then he leaves it there? That tells me he thinks there's an order. Because if he'd have known, if Mark Bennett, competent defense counsel in this case, had known there was no order, his closing would have been very simple. She doesn't even know that there's no order. She says she did this because here's the file. There's no order. There's no record here. If he'd have known it, he'd have done it. He believed it was there, and that's why he didn't hear about it. Everybody's actions here speaks volumes about the communal knowledge in that courtroom. If Judge Parrish would have believed there was no order, the people here who have worked with her know, she would have brought everybody up and said, there's no more speaking of the order because there's no order. She believed it was in that file. Defense counsel believed it. How do we know that? Because he'd have clobbered her over the head with that fact in her closing argument. Collectively, the community believed it existed. And it's not the best analogy, but that's what believers do, right? We believe this is our truth. And once we believe this is our truth, we don't question it. In fact, we become more confident in it. There's a psychological phenomenon for it. And I will think of that hopefully in a moment. But the Kruger-Dunley effect is the less you understand, the more confident you're right. And it's a well-known test. that they give to people because confidence and competence are generally this far apart. If I don't understand physics very well, I'm pretty sure I understand how molecules work. And the more I learn, the more I know that I don't know. And so that's the psychological phenomenon which explains Miss Spradling's belief. She is, as I say, a devout believer. She knows what's on the other side. She believes that. There's nothing we can do to move her off of that. It's the way the mind works. Everyone has a set of believed truths. And once those truths exist in your head, until you're able to walk it back, you don't question them.
Have other questions of Mr. Leatherman? Mr. Leatherman, we've obviously taken on a lot of your time with questions, so I do want to make clear that we would be willing to give your client an opportunity to make a statement if that was your plan, despite the fact you're out of time.
After what happened last time, my plan was not to let her speak.
Okay, that's fine.
But if any of you would like to speak to her directly, she is willing to answer your questions and apologize. And if any of you would like to speak to her.
Questions, so thank you.
Thank you for the generous use of your time. And I know that you will give her the same courtesy and dedication that you gave Ms. Chandler, and that you will do well with this, and I sincerely appreciate it.
Mr. Vogelsberg, you reserve 3 minutes. I think we can be somewhat generous with that, given the volume of exchange that occurred.
I had one thing that I didn't ask about the recommendation, because the panel recommended disbarment, and I understand your material to be you're still at indefinite suspension, and I just wanted to hear why real quickly, and then, because I know you've got a lot to respond to.
Right. We recommended indefinite suspension at the hearing. There has not been any evidence that would have come out to decide to increase the recommendation. I don't know if that would be even appropriate, since we made indefinite suspension recommendation at the hearing. Additional facts that I will mention, and I did receive counsel's permission to mention these facts, is that after the hearing panel report came out, Ms. Spradling did resign from her positions as a prosecutor at Allen County and in Bourbon County, and that she also voluntarily went on inactive status with her license. So I think those are additional facts that this court could consider in applying indefinite suspension to her. I do want to mention a couple of key points. Counsel was talking about that the 60-455 order that came out, that Judge Parrish wrote, that referenced a October 1998 PFA. He's claiming that that established a good faith basis to then subsequently ask Detective Voley on the stand about the PFA, and then after that, make that argument in closing. Ms. Spradling appeared in front of this court in January 2016. She claimed that the basis for making that argument and even questioning Voley was because Detective Voley told me prior to trial, and family members told me prior to trial, that an order had resulted from that 1998 motion. That was the basis she gave. In her sworn statement that she gave in July of 2018, again, Detective Voley told me this. Family members told me this. Well, when we eventually get to the disciplinary hearing, Detective Voley testifies there. The panel got to witness his demeanor, and he testifies that, I don't have any memory of ever verifying that a PFA was in place. I certainly didn't tell Ms. Spradling that. And so that discredits her claim of having a good faith basis for making that argument. Furthermore, there were no family members that came forward to corroborate her claim that they told her that MS had received an order keeping Chandler away from him, or an order that resulted from that October 1998 motion.
So can I clarify, did he say he has no memory of it, or he definitely did not?
His testimony at the disciplinary hearing claimed that he did not verify that he did not. He said that he reached out to Douglas County, contacted them to see if there was any evidence of an order that had resulted from that motion, and could not verify that.
Did testify that it would have been a very important fact for him if he had been able to.
He indicated as well that it would have been included in the affidavit in support of the arrest warrant as well.
I have kind of a procedural question. Mr. Leatherman suggested that your office, I'll use the word threatened, although that's too strong of a word, threatened to add a ethics violation for failure to cooperate if she did not submit to a deposition. Is that accurate?
I can't say that she ever received any threats. I do not have any personal information of that. All I can say is that under the Supreme Court rules that the disciplinary administrator's office does have the ability to take depositions of respondents, and that if a respondent failed to cooperate in that, that would result in a failure to cooperate in the disciplinary investigation.
Okay.
But I have no.
Do you think a respondent in one of your cases has the ability to avail themselves of legal process to challenge procedural steps taken by your office, or is that ipso facto failure to cooperate?
Certainly, the respondent could make a challenge. They could argue because of some circumstances they're not able to sit.
Or just whatever the argument might be.
No, it's like if we were scheduling a deposition of a respondent and the respondent said, because of circumstances, I cannot come.
What if they
reschedule it.
said, this is improper? You're not allowed to do this.
Well, again, I would cite to the Supreme Court rules.
I guess what I'm asking is
cite
just, is it your office's position that respondents just have to roll over and do whatever you say, or they're not cooperating?
They have to cooperate in the investigation.
So they have to do what your office tells them to do.
They have a duty under the Supreme Court rules to do that.
Is there an ability to go to the hearing panel to postpone or delay this? I'm really trying to ask about the procedure here.
As far as when the deposition took place?
Yeah, if you guys want to take a deposition, the other person doesn't want to do it, what do they do? I took Justice Stiegel's question to be, is there a process to object?
At that point in the proceedings, the review committee had not ruled that this matter was going to go in front of a panel hearing, so a panel had not been assigned at that time. I suppose that if a respondent believed that they did not need to sit for a deposition, they could maybe file an objection with the chair of the Board for the Discipline of Attorneys. But I'm just thinking off the top of my head about that. I would just ask this court to affirm the findings of fact that the panel made, to affirm the conclusions of law that they made, and impose an indefinite suspension upon Ms. Spradling. Thank you very much.
Thank you to both counsel for your arguments today. The court will take this matter under advisement. The court is adjourned.